This week in Tribal Law, we take a look at cases and legislation impacting Native Americans across the country. At the United States Supreme Court, docket number 17-532, Herrera v. Wyoming. The question before the court in this case is whether Wyoming's admission to the Union or the establishment of the Bighorn National Forest abrogated the Crow Tribe of Indians' 1868 federal treaty right to hunt on the unoccupied lands of the United States, thereby permitting the present-day criminal conviction of a Crow member who engaged in subsistence hunting for his family. Oral arguments in this case were heard on January 8, 2019. Docket number 16-1498, Washington State Department of Licensing versus Cougar Den. The Yakima Indian Nation owns Cougar Den, a fuel distributor that imports millions of gallons of fuel into Washington annually for sale to the general public. An 1855 treaty between the United States and the Yakima Indian Nation provides members of the tribe the right in common with citizens of the United States to travel upon all public highways. The state of Washington seeks to tax Cougar Den for transport of fuel on state highways. The question presented is whether the Yakima Treaty of 1855 creates a right for tribal members to avoid state taxes on off-reservation commercial activities that make use of public highways. Oral arguments in this case were heard on October 30th, 2018. Docket number 17-1107, Carpenter v. Murphy. The question before the court is whether the 1866 territorial boundaries of the Creek Nation within the former Indian Territory of eastern Oklahoma constitute an Indian reservation today under 18 U.S.C. Section 1151A. Additionally, an order was issued on December 4, 2018 for a supplemental briefing addressing the following two questions. 1. Whether any statute grants the state of Oklahoma jurisdiction over the prosecution of crimes committed by Indians in the area within the 1866 territorial boundaries of the Creek Nation, irrespective of the area's reservation status. And 2. Whether there are circumstances in which land qualifies as an Indian reservation, but nonetheless does not meet the definition of Indian country as set forth in 18 U.S.C. Section 1151A. Oral arguments were heard in this case on November 27, 2018. Meanwhile, at the United States Court of Appeals, 9th Circuit, docket number 17-56003, Agua Caliente Band of Quia Indians versus Riverside County. In this case, the tribe in question is appealing a summary judgment of the U.S. District Court of the Central District of California, which held that Riverside County could assess and collect a possessory interest tax from non-Indian lessees of Indian trust lands on the Agua Caliente Reservation. The case was argued on January 8, 2019, and the lower court's decision was affirmed on January 28, 2019. Docket number 17-35722, Stillaguamish Tribe of Indians versus Washington. The Stillaguamish tribe entered into a contract with the state of Washington in 2005 concerning construction on the Stillaguamish River. This contract contained an indemnification provision in which the tribe agreed to indemnify, defend, and hold harmless Washington from and against all claims arising out of or incident to the tribe's performance. March 22, 2014, a major landslide occurred 4 miles east of Oso, Washington, impacting 49 homes on the south side of the North Fork of the Stillaguamish River. Victims of this landslide brought suit against the state of Washington and ultimately won a settlement for $50 million. During and after the lawsuit and settlement, the state of Washington stated that it would seek indemnity from the tribe. The tribe then sued the state of Washington in federal district court, claiming that sovereign immunity would bar any suit from the state for indemnity. The district court granted summary judgment to the tribe. The 9th Circuit review of the decision resulted in the lower court's decision being vacated and remanded back to the lower court with instructions to dismiss for lack of subject matter jurisdiction. This case was argued and submitted November 8, 2018, in the opinion of the Court of Appeals filed on January 22, 2019. Native American sovereignty and rights are contested and affirmed in the court system. Stay up to date on the status of these battles with Mvskoke Media.